Okay, now, as far as today is concerned, we've got 12 questions we want to get through in the hour, and it's the same format as before. So we've got a main speaker and then a follow-up with some additional comments from somebody else from the panel. These are the questions, just so you know, you would have seen them, but how do local authorities make robust assessments of supply in the absence of data? How to determine a planning application in the absence of site visits? How can the public be involved in planning inquiries and hearings? How can that be safeguarded? To avoid a sterile debate at EIP, should terrible plans fail faster? How will COVID-19 affect continuity of use for the purpose of immunity against enforcement action? How will cross-examination work via video conferencing? How are we going to assess viability in the light of limited comparable property transactions? The eighth question is, post this crisis, will the government give local planning authorities a chance to catch up on the delivery of their development plans, or will economic recovery and growth take priority? Ninth question, what about public participation in local examinations, which we know is more complicated than appeals? 10 is, what do local planning authorities need to do on a practical level for conducting a virtual planning committee? 11 is, do we really need to wait until May 2021 for neighbourhood plan referendums? And the final question is how to investigate and gather evidence on alleged unauthorised internal works building during lockdown. So those are the questions we're going to answer, and we'll go around the panel to do that. Now, the first question, how do local planning authorities make robust assessments for supply in the absence of the data? I'm going to tackle that one. There's one main point above all others, which is that local authorities should contact the development industry. They should contact them and find out what is going on. Now, I know that happens already, but the reality is this needs to be done on a much more sophisticated level now. And I would suggest that it needs to be done with a nominated officer for whom this is a key and possibly their only task, somebody probably from the forward planning team. Secondly, that person needs to review the situation on all the major sites every week and have a lot of dialogue with those involved in the sites, because this position is going to change significantly. It's fantastic that the show homes are now open and other people's homes can be viewed by estate agents for the purpose of allowing the whole market to move on and transactions to take place. But for those new homes that we're critically interested in for the purpose of delivery, then obviously the show homes opening is really, really important. Now, we know that there's been a drop in prices. Savills reckon it's as little as 5%. Other, perhaps more independent organisations less concerned with transactions in the market are suggesting something bigger, around 10 or 13%. But it's certainly a lot less troubling than many might have thought. But the real answer is we don't know. We just don't know, and we don't know because we don't know how badly the economy has been affected and what that means for how many people have lost their jobs and how many people will be re-employed. The furlough scheme is obviously there to protect pretty much everything that we do by maintaining incomes, but we just don't know. I personally think there'll be an awful lot of people who want to get out of the house they've been in and move to somewhere bigger with a garden, which would be fantastic for the house building industry. And everybody knows what I'm talking about because we've all been living with our families for too long now without enough respite. Now, over to Thea, who is going to provide some additional thoughts on this.
Yeah, funnily enough, Chris, I have a friend in exactly that position. She is now looking to move because she wants a garden, having not been able to kind of experience that for the last few weeks. So I absolutely agree with that point. While we're on a housing land supply theme, we've had a lot of questions about the housing delivery test and whether we think the government are going to relax that in due course so that local authorities are not sort of penalised, although I don't like using that language, for not having delivered sufficient housing during this time. I think there's a couple of points to be made about that. first is that for the next round of housing delivery test results, which should be in November of this year, lockdown will only represent about 2 weeks out of the 3 years that go into that those results, essentially. So I don't think the effect is going to be felt this year, but of course it will be felt next year and then until 2024. But the next results that are actually going to show the impact, I think, of this crisis will be in November of next year. And in policy terms, 18 months is a very long time for the government to understand the impacts of the crisis and also to figure out what an appropriate policy response to it is. And we could see a whole range of policy responses to it. I don't think necessarily it's helpful to speculate at the moment what's going to happen with the housing delivery test, because it just could be one part of a load of measures that deal with the outcome on housing delivery of lockdown.
Yeah, absolutely. I mean, I think there'll be a lot of pressure on the government to change things, but they'll be reluctant to do so. The last time they changed the 5-year land supply test was for neighbourhood plans and the 3-year test, and that all ended up in litigation. So I think there'll be a reluctance to change it, although a lot of local authorities would obviously like to see that. Okay, well, thank you, Thea. And moving on to our second question, which you're going to have to answer as well. But after Leanne, how to determine a planning application in the absence of a site visit. So, Leanne, your thoughts on that?
Yeah, so Chris, the question obviously focuses upon the absence of a site visit, but I do still think it's important to consider whether or not site visits can take place physically pursuant to the regulations. And in short, my personal view is that they always have been able to. If we look at Regulation 6 in particular, that states that no one can leave the place where they're living without reasonable excuse. And we see at subparagraph 2F that a reasonable excuse does include the need to travel for the purposes of work, where it's not reasonably possible for that person to work from the place that they're living. So if we think about site visits, that's clearly something that one would carry out in accordance with their work and that they can't do from home, you would think. I just should also point out that Regulation 7 deals with gatherings, and that refers to gatherings of not more than 2 people. But again, we do see an exception here in relation to work-related requirements. Now, the amendment regulations came in this week. I'm not going to read out the long title of those, but I just point out as well that Regulation 2 doesn't change any of what I've said in terms of Regulation 6 and 7 in the previous regs. So whether or not a physical site visit can take place, in my view, depends on 3 things. First, whether or not its completion is really needed as part of one's work. Second, whether or not more than 2 people need to attend, and if so, is that gathering essential? And thirdly, is it safe? So can social distancing be adhered to? Now, one example of a site visit that might not be considered to be needed at present is where there's an alleged breach of planning control, the time limit for enforcement has a really long time left to run on it, and there isn't any emergency issue at play. Obviously, it depends from authority to authority on their decision taking with regard to that, but that's one example where maybe delay would be reasonable. It also, Chris, might be that a site visit could be carried out remotely from home, and this brings us back to the question. So how could that be done? Well, really a combination, I would say, of something like Google Maps. We can put the little pinned man, can't we, on Google and have a look on the ground. So provided that's relatively up to date, that would be very useful, but also photographs of the site. And it's important, I think, for anyone who's submitting a planning application at the moment to be very mindful of that and ensure that any photographs that they submit are plentiful and good quality. I also just want to flag for anyone who hasn't seen it, I'm sure you all have, the Inspectorate has now provided detailed guidance, and they've made clear that they will be commencing site visits where it's safe to do so, as well as considering whether there's types of cases that can proceed without undertaking a site visit. And they've noted that they're going to be having their case officers contact parties about how arrangements will take place. So in my view, Chris, finally, it's not unreasonable for local authorities to take that similar approach that the Inspectorate is now taking.
Yeah, I mean, it's a very difficult one, isn't it? I have to say, I'm doing a site visit ahead of an appeal. I have to see the site before an appeal. It's another part of the country, and I'm going to go and do it because there's no risk, and it is essential to my job. And landscape architects are out doing their job. You know, it's 2 meters isn't that far apart. If you stood in a supermarket queue recently, it's all perfectly manageable outdoors. Jack, your views on this as well, please.
Yeah, well, the first thing I'd say is there's no requirement for councils to undertake a site visit, and it's not uncommon, particularly for smaller schemes, for council to determine planning applications simply on the papers and representations rather than relying upon a site visit. And plainly, the importance of the site visit will depend on the circumstance of the case. So, for example, if you've got a case where the objection relates to modal sustainability, so i.e. how remote the site is from services and shops and schools and so on, or if there's a technical highways objection, in those cases, the importance of the site visit will be diminished. In contrast, if you've got a landscape or heritage objection, that places more importance on the site visit. But even in that case, a site visit is not essential. 20 years ago, it would be difficult to assess landscape absent a site visit, but there's now an embarrassment of riches online of all the tools which Leanne has mentioned, and there's no reason why that can't be done. I'd underline one thing Leanne said, which is the importance, in particular, of photo montages. So we all got used to that when there was the growth of wind turbine appeals 10 years ago or so, and photo montages are a very helpful tool for decision makers to assess impact on character and appearance.
Good, thank you very much, Jack. Some interesting observations there. Okay, our third question then is, how can public involvement in planning inquiries and hearings be safeguarded? Your turn, Thea.
Thank you. Well, Chris, the big news this week, of course, is that on Monday, the first fully digital hearing took place, and it's been described by PINS as a success. So this can be done, and the Inspectorate are hoping to follow with a further 20 examinations, hearings and inquiries over the course of the next 2 months. So this is all really good news, and the message is we need to get ready for the digital appeal. Now, my preference is for video hearings rather than telephone hearings, which I think are much more effective. I did a Section 289 High Court hearing last week, and I could see when the judge was looking at the documents or making a note, and those are, of course, important things for an advocate. Now, if people have a computer, then it's pretty easy to join with a digital hearing. They join the hearing through the link provided. There are all sorts of controls, which mean that the host, PINS, decides who can be heard and who can be seen. Now, I suppose the difficulty is when people don't have a computer. They're very much in the minority, but there should be no reason why people can't dial into those hearings. Again, that was the case with the High Court hearing I did last week, because the solicitor, one of the solicitors involved, didn't have video capacity. So ultimately, public participation is really important. We know that, but there are lots of reasons why people involved in planning inquiries can't always be there. They might have jobs to go to, childcare issues, they could be on holiday. And that's not a reason to not continue with the planning inquiry. But those people who can't make it by computer should be offered the chance to join by telephone. They can also be given they can nominate someone to go along and make representations on behalf of them. I think it's a good idea to record the process so that people can, in fact, review the footage afterwards and still feel that they're taking part in that way.
Good, thank you very much, Thea. And James, your observations on that as well, please.
Chris, yes. So it may be helpful to consider this as 3 main forms for direct participation by members of the public, as opposed to simply observing proceedings through a webcast. And each of these 3 formats will be accorded the same weight by the inspector. That's obviously first the written statement, second a video and telephone appearance, and thirdly an assisted or a proxy appearance where someone reads a statement on behalf of another. And I think that latter category is important because there may well be situations where a member of the public is without computer access, but they still want to have their contribution to be heard by the inspector at the appropriate moment and not merely read. Now, the 2 keys to making this work are going to be 1, advance notification, and secondly, concentration in the submissions. In respect of advance notification, if an individual wishes to make a video appearance, they're going to have to notify the inspectorate or the LPA, who will then in turn notify the inspectorate so they can get the login details and so forth. And the same will apply for a proxy appearance. So the inspector or the LPA may recommend that that individual requests in advance of a third party, a family member, a friend or a neighbour, that they read their summary written statement online. But the second key component, concentration, In all cases where statements are read, I would envisage that the inspectorate is going to impose some kind of word limit or time limit, say 500 words or 5 minutes, to ensure that the proceedings run to time.
Right, we move to our fourth question, and that is to avoid sterile debates at examinations in public for local plans. Should terrible plans fail faster? James.
Well, Chris, thank you very much to Roy Pinnock of Denton's for this question. In summary, I absolutely agree, but it's going to require innovation in at least 3 key respects: procedure, policy, and politics. Looking first to procedure, there's definitely scope for some kind of preliminary hearing or a written summary judgment process to be scheduled much earlier in the examination process, where an inspector has identified on a preliminary read-through that there is a fundamental flaw in the plan. The history of the most recent high-profile plan failures shows that inspectors' preliminary questions and their interim communications have often given away that they had serious concerns about, for example, the duty to cooperate or an artificially low housing requirement very early in the process. So I think that one could schedule a preliminary hearing or a written submissions process, perhaps within a period of 1 to 2 months from the plan submission date, subject of course to inspector availability. And that preliminary hearing could be attended by the LPA and a limited number of participants who've been identified by the inspector as representative of key stakeholders or key groups. And then the inspector could then issue a written decision, perhaps within 7 to 14 days. But secondly, moving to policy, none of the above can happen without specific changes to national policy as it's currently drafted in the NPPF. The provisions of the NPPF are worded in such a way that they leave a very wide room for argument on some of these issues, on both the duty to cooperate and soundness in respect to provision for housing. For example, paragraph 11b, which requires provision for OAN as a minimum, that should be subject to much narrower exceptions. And the same applies to footnote 5 of that same paragraph and the significance of a statement of common ground in confirming compliance with the duty to cooperate. Looking ahead to paragraph 35 and the Soundness Tests, the requirement of positively prepared, there is unfortunately too vague wording in respect of meeting of unmet need, simply saying where it's practical to do so and consistent with sustainable development. So the tests need to be much harder edged, and I could go on. But the headline point is that one cannot at issue envisage a summary judgment on a plan when the policy on soundness remains so vague, which leads, of course, to our third factor, the politics. Government will need to communicate with LPAs, both through the text of policy, but also through their direct contacts and their meetings with members and officers, that there's no room for exceptionalism. There are no special cases. There's a strong hint in the communications we've seen from various high-profile plan failures that those authorities consider they should be subject to some kind of more lenient approach. And government needs to communicate that that's not possible from the get-go.
Okay, so thank you very much to James. We move on to our fifth question, and that is, how will COVID-19 affect continuity of use for the purpose of immunity against enforcement action? A lot of people are asking us this. Enforcement obviously presents specific problems. And I turn to Jack for the answer to this, please.
That at any point during that time, the council could have taken enforcement action. I'm unaware of a case where the council has disputed that the use has taken place at all. Much more common is a council identifying a break or an interruption in the use, which restarts the immunity clock. Whether a pause in the activity breaks immunity is quintessentially a matter of fact, and the lockdown is plainly a material consideration. So give an example, what if an activity is paused for 2 months involuntarily on account of the lockdown? Does this restart the clock? The answer isn't entirely straightforward. In terms of residential use, there's a distinction to be drawn between occupation and use. So by way of example, if I leave my home and go off on a cruise, the said to continue, provided that my apartment remains kitted out as a home. A dwelling does not cease to be a dwelling if it is unoccupied. So it seems to me that in respect of a business involuntarily closed, provided the premises is set out for that purpose, the fact that it has not operated from those premises during the lockdown probably would be insufficient to restart the clock. So an applicant would be on fairly firm ground during April, but as we go down the road of easing restrictions, the position becomes murkier. The longer the period of inactivity, the more likely it is that immunity is broken. If the inactivity continues into June, when there are fewer restrictions and a greater enthusiasm to return to work, the applicant will face a steep climb to satisfy the local authority that immunity is being accrued. For those acting on behalf of applicants, the priority should be in demonstrating those aspects of the activity which can be kept up during the lockdown to show a residual use. Whilst the question of a break in immunity is objective, the intention of the occupier has some relevance. If the bare bones of work is being undertaken remotely, and there is good evidence of an appetite to return to work as soon as possible, this will support an allegation of immunity. So too will the fact that the physical fabric of the premises is intact.
Great, thank you very much, Jack, and I hope you do get to enjoy that cruise in due course. Over to Leanne, and your views, please.
Well, Chris, sadly, I'm not due to go on a cruise, nor do I think I'll probably be allowed at the moment. But in terms of the answer, I do agree with Jack that it's not straightforward, and obviously it's going to depend upon the facts and degrees in each particular case. And I also agree, actually, that it's more likely to be an issue with non-residential uses, particularly given the present focus on staying at home. But one thing that I can perhaps suggest that might assist is a case, Miles and National Assembly for Wales. This is a case where the applicant was challenging the dismissal of his appeal against the decision of the authority to refuse a certificate of lawfulness, and that related to use of land for recreational motorcycling activities and farming. Now, in that case, the inspector on appeal had concluded, amongst other things, that the land hadn't been used for motorcycle activities for approximately 18 months when foot-and-mouth disease had broken out. So I'm sure many of us can remember that time. One of the applicant's arguments in response to that was that enforcement action could still have taken place during that period. And so as a result, that time should count, even though motorcycling activities didn't take place. But he failed in that argument. So the court said in relation to that during the period of the outbreak, there was no question of enforcement action taking place, so the period couldn't count. The cessation was an interruption that was of such significance as to stop the accrual of immunity, if I should say immunity hadn't already been accrued by the date of the outbreak. So I think we can try to draw a comparison, although it's fact-specific, with that case. And it does seem to me that the following points are key. First, whether or not immunity has already been achieved prior to coronavirus outbreak. That will obviously assist you greatly. Whether or not there's been a complete cessation of activity, or if some activity has continued, as Jack has noted. How long is the period? So clearly the longer that it endures for, the more likely that there's going to be a break in immunity. And is there really no question of enforcement action like in the Miles case? Think about Regulation 6, as I've already outlined in relation to site visits, and that work can still be done within the remit of that. But I should also say that is a bit of a double-edged sword, because of course Regulation 6 would also allow, particularly in business-related uses, for people to visit their premises and carry out some element of work during the time. So if nothing's done, that argument could be used against you as well.
Good. Thank you very much, Leanne. Very helpful and disappointing, obviously, for all those people trying to get away with a house that they think nobody has noticed. And this might be an interruption that affects that. OK, now, the next question is how will cross-examination work via video conferencing? And we get asked this a lot. So, Thea, what's the answer?
Well, is there an answer? I don't know, but I'd be really keen to hear what other attendees on this webinar think about this, and whether or not you're looking forward to cross-examination via video, which I'm really looking forward to doing. And I don't see any reason why it can't be done properly and done well, providing that everyone involved has the right technology to do it properly. So 3 main tips from me. One, a good internet connection is obviously essential, as is a video connection, because part of cross-examination is to assess the credibility and demeanour of the witness. Now, that's possibly less relevant in respect to professional witnesses, but nonetheless, it's important, I think, for the advocate, witness and inspector all to be able to see each other clearly. Point number 2, I think you need more than one screen, and 2 as an absolute minimum. So you need one to look at the person you're engaging with, and another to look at the digital core documents which we're going to be dealing with and be able to navigate that bundle really well. Ideally a third, perhaps for your proof of evidence, but I think, as I said, 2 is a minimum. I've got a 3-screen setup at the moment out of necessity rather than choice, but I'm certainly seeing the benefit of it. And you can pick up screens relatively inexpensively for around £70 to £80 from online stores, and I think that appellants and counsels should be helping their witnesses with that. Final point number 3, don't just turn up in your pants like Will Reeve did on Good Morning America. The need for suits has not gone out of the window because of COVID-19.
Yeah, that is a real shame. I was hoping to wear surfing gear for some of this stuff, but apparently that's not the done thing. No? James, cross-examination through this medium. Your thoughts?
Chris, so cross-examination under video conferencing is going to be shorter for 3 reasons. First, inspectors are going to seek to limit its duration at the case management conference or in a later direction. Secondly, advocates are going to recognise that viewers inevitably have shorter attention spans, and so those advocates will self-police. And thirdly, witnesses will be in the spotlight and therefore will not prevaricate. However, everything depends upon having an effective digital bundle with a clear system of pagination, as I discussed last week.
Good. Thank you very much indeed. And the next question then is, how are we going to assess viability in light of the limited comparable property transactions? And I'm going to address this issue and do so in 2 parts. The first is, in terms of the transactions that are happening, obviously, if we're trying to build a viability assessment, we need the sales values of the properties. And for those sales values, we obviously need properties to sell. So it is absolutely vital now that the housing market can move. And whilst there's been a lack of transactions up to now, hopefully there's going to be a lot of transactions. There will be people who have been waiting to move, people who've been thinking about a move and are now very, very convinced about the merits of that. I think we are going to see a real spike in the amount of transactions that take place. So I don't think there'll be a difficulty with that. And I think values will drop, but I think we don't know precisely how much that is. There'll be very, very careful monitoring, I think, from the major estate agents and the house builders of that data. The other side of this, though, is land and the limited transactions in land, and that is more complicated. There has been, obviously, a complete cessation of the transactions in land for most of the major house builders. Many have withdrawn from the market. We do see some transactions, and we all welcome seeing that on LinkedIn and other social media, and we try to like it because it's all very encouraging. But the lack of transactions is an issue, and the drop in sales, if it is 13% or even if it's just 5%, has a greater effect, obviously, on the value of land. So we don't know exactly what the effect will be when you're looking for comparators. My view would be, if it is a 13% drop in sales values, then it's probably about a 30% drop in the value of land. But, you know, that will very much be dependent on what actually happens, and we start to see more transactions. And all of this arises, this is a really good question, because the PPG is clear that viability appraisals should be based on existing use value plus, or EUV plus, as we call it. And there is no definition of the plus, which means nobody has any idea what EUV plus actually is, other than something more than existing use value. And that is why you inevitably have to use comparators now. There are other methods to deal with viability, better methods, but this is the method, and that transactional data is vital to that. So I would work on previous transactions minus 30% for now. And that obviously is going to affect the viability and the affordable housing on a lot of sites, but all needs to be carefully monitored. Now, if I can bring in Thea, who has got some additional comments on that as well.
Yeah, thanks very much, Chris. I don't know if you've been following Robert Jenrick on Twitter. He's certainly been getting a lot of stick over the announcements made yesterday. But he's made the point very clearly that the industry is inextricably linked to the economic health of the country. And really, I guess I had a question for you that how quickly do you think we will see a return to normal or business as usual?
I think that the government are very, very aware of how important the construction industry is. So when a lot of the staff were furloughed from the major house builders, the government was very quick to say, well, we didn't mean transactions, we didn't mean construction, and we didn't mean you to stop anything else. So I think it will bounce back. I think the real unknown factor is how people are feeling about their job security in the coming months and years. And I'm optimistic. I'm really optimistic. And I hear, and I know that Robert Jenrick is getting a lot of stick. I think he's the right person for the job. He's definitely very positive, a lot of positive decisions. And I think we're going to bounce back pretty quickly after the announcements yesterday. Okay, so we're going to move on. And the next question, we're on to our 8th question. After this crisis, will the government give local planning authorities a chance to catch up on the delivery of their development plans, or will it be economic recovery and growth that take priority? James, your views on that?
Chris, well, thank you to Simon James of DLP Planning for this question. My view is that the government should focus on economic recovery and growth. So I'm in the hawk camp on this one, to borrow terminology from an early article by Matthew Spry of Lichfields. I think there are fertile conditions for a growth-centred approach, looking at 3 factors: plans for reform of national policy, secondly, the political climate, and thirdly, regulatory changes. So looking first at current national policy and its plans for reform, both the revised NPPF 2019 and the recent Government Planning for Recovery paper are a very pro-development plan. They envisage quite a long lead-in time, it seems to me, up to 2023. And my view is that both of those now read as somewhat out of date, allowing LPAs somewhere in the region of 2 years to get their plans in place, or in the case of recently adopted plans, to allow sites to build out more slowly, in my view, is a recipe for a slow recovery. So my view is that government should be turbocharging the presumption, indicating it will be applied with full force in the case of a 5-year housing land supply deficit or emerging datedness in the plan in respect of its choice of allocations or its policy wording. So looking then to the political climate, government understandably is going to be concerned about opposition to new development in areas for potential new development. And understandably, local residents have now spent many hours looking out over or walking through potential development sites. However, given the scale of the recession, given the scale of the economic figures we've seen, government now has a much stronger platform than ever to prioritise economic growth. And then moving to the question of the law and the regulatory position, what we've seen is that government is moving with ever greater speed in the policy making and the regulatory sphere, as we saw yesterday in the written ministerial statement. So my view is that government will be content to abbreviate the consultation periods on new national policy and to shorten or simply do without transition periods to allow for changes to national policy. And all of this ultimately is characteristic of crisis-era planning. Government needs to be robust, assertive, economically focused, because the scale of the challenge is so great.
Thank you, James. Thank you very much for that. Now, my own view on this, if I can just add that, is that the government will be loath to do anything to change the development plan process. They are already frustrated with councils, so I don't think there will be any leniency given to local authorities. There's a number who have suspended progressing them, like Horsham, who were ready to progress their plan to Regulation 19 stage. And I just don't think the government want to go there. I think they'll want to encourage the continuation and the use of local plan work. So that's my view on that issue. Okay, now we move on to our next question. And the next question is, what about public participation in local plan examinations? And Thea, you're going to answer that.
Yes, I will. Similar to inquiries, really. We dealt with participation by people entitled to speak last week and how that could work. And as many of the people watching will know, Section 20, subsection 6 of the 2004 Act says that any person who makes representation seeking to change a development plan document must, if they want, be given the opportunity to appear before and be heard by an inspector. So that's why you don't get loads of members of the public speaking at examinations. It's closely controlled and the participants are known in advance. So in that respect, it's a little bit easier than hearings and inquiries because everyone who would want to speak is known. It can be live streamed. It should probably be recorded. And if people don't have access to a computer, then again, they could listen in by phone, and access details to do that should be, in my opinion, made widely available.
Good. Thank you very much indeed for that. And James, your views on that as well?
Yes, Chris. So the written ministerial statement that we saw yesterday makes clear that the ministry and PINS are looking at the key criterion of flexibility. However, to echo one of my earlier answers, my prediction is that one of the major themes we're going to see is concentration. So that means inspectors asking participants to time limit their contributions. And they may also ask certain participants to group together in their agenda questions rather than allow for many duplicate submissions. So overall, I'd envisage continuing emphasis on public participation, but also a lot of emphasis on proportionality in respect of the procedural format.
Good. Thank you very much, James, for that. And time-limited submissions, I think, would be very welcome indeed. Certainly in the US Supreme Court, they limit the submissions, even on the really serious cases, on constitutional issues, to 30 minutes. Although when James and I were in the Supreme Court with the Richborough case, I was allowed to waffle on for about 3 hours. They let you know when they've had enough, though. That was very clear. And all of that was recorded like this, embarrassingly, so everybody can watch everything you say. OK, we move on to our next question then. And that is, what do LPAs need to do when holding a virtual committee? Now, lots of discussion about this, but I know both Leanne and Jack have been speaking specifically to local authorities to find out about the practical issues of just getting these virtual meetings up and running. So first of all, then, it's over to you, Leanne.
Yes, Chris. Well, in my view, the main thing really that a local authority needs to do is to ensure first that it understands the power by which they can hold such meetings, but also the limits to that. And I'm not going to read out the lengthy regulation title, but I'm sure you're all aware of the one that it is. It's the one that refers to police and crime panels, but it will be on the slides for you. And that effectively gives effect to Section 78 of the Coronavirus Act. And it applies to all local authority meetings that are held before the 7th of May next year. And that's in Regulation 2. As to what local authority meeting means, you need to see Regulation 3. But I would just say that it does apply to all local combined national park authorities and also joint planning committees as well, where they're established under PCPA. Now, it's Regulation 5 really that you need to look at in terms of the enablement of remote meetings. And that makes clear that where legislation refers to a place, that now does include more than one place, which is helpful, but also electronic, digital or virtual locations. And examples given within Regulation 5 include internet locations, web addresses, and conference call telephone numbers. So that's the case even if the local authority's standing order at present, or indeed any other rules governing the meeting, includes a prohibition or restriction in relation to that, and that you see at Regulation 5.5. In terms of the attendance of your members, well, remote attendance is permissible as long as they can hear and be heard by all other members, public that are entitled to speak, and all other members of the public that are there listening in. I should just also point out that video is only required where practicable, so if you have members where that just isn't possible, that doesn't mean that you're going to have an issue in terms of meeting the requirements. In terms of public attendance, open to the public we now know is defined as including access to the meeting through remote means, and this is described as including but not limited to, might I add, video conferencing, live webcasts and live interactive streaming. So what are the limitations you need to think about? Well, Regulation 5.5 that I referred to a moment ago applies to the location of a meeting, but what it doesn't do is apply to the voting procedure. And those of you that work for local authorities will be aware that some of you may have standing orders that require voters to be present when voting. So you'll need to consider whether or not you need to amend your standing orders to ensure compliance with them to deal with that issue. Regulation 5.6 allows for standing orders and other rules to be created that provides for voting, and I should say other things as well, including public access to documents. What you might be thinking is, well, how do we vote on amending a standing order allowing remote access when we would need a remote meeting to do that? That's quite a fair question. And I would say that the purpose of Regulation 5 would be completely thwarted if you couldn't hold a remote meeting to decide on such an issue. So you're probably okay, but it isn't specifically dealt with as far as I can see. Practically then, finally, what we need to look at, well, you need an appropriate platform. You need to decide on that. It needs to obviously be accessible, it needs to be secure, and it needs to be GDPR compliant. You also need to think about the fairness of that platform in accessibility terms. So looking at the Equality Act 2010 and how certain platform choices might impact those that want to join in. You might need to consider equipment needs of your members and whether training is required for them to understand the platform that they're going to be using. And practice. Do a practice run. Make sure that everyone understands how it works and try and iron out any issues beforehand. And finally, I would say you need to think about what your procedure is going to be if things go wrong. So if you have any technical or connection issues, particularly where you might have a certain quorum of members needed for a vote to be valid, you need to think about what you're going to do if somebody drops off during a key or vital decision-making moment. So those are my tips, Chris.
Yes, well, I think it very, very significant. We've all had technical problems, haven't we? We all know what that's like. And it really is about thinking ahead. Westminster City Council have said that they needed to think ahead about the problems and how to resolve them. And if they wanted to stop the meeting because of porn bombing, as it's been called, then you need to have a procedure and decide if you can do that immediately rather than have to take a vote about whether you don't really want to hear any more of those kind of noises. Anyway, moving on, and Jack, you've got some thoughts as well.
Yes, Chris. South Somerset Council hit the headlines when its first virtual planning committee meeting by Zoom was interrupted by people joining under explicitly suggestive names. The deliberations of the committee were interrupted by what sounded like an audio from a pornographic film. My research indicates that all local authorities have had to amend their standing orders to allow remote meetings. Rugby Borough Council is using Microsoft Teams. A number of mock meetings have been held, and the council intends to go live on the 1st of June with a cabinet meeting. It's anticipated that all meetings will be live streamed from its website, and where public speaking is part of the process, eligible people will be able to dial in using an ID code. East Cambridgeshire District Council uses Zoom. In advance of the planning committee meeting, the agenda and Zoom link are advertised on the YouTube page and the council's website, together with Twitter and Facebook. Applicants and neighbours are notified directly of the link. 2 days before the meeting, all members, officers and speakers are given the access code, and asked to log on at 12:30 in order to allow for a prompt start at 1 in the afternoon. Those registered speakers are encouraged to provide a copy of their speech in advance so that it can be read out in the event that there is some technical issue. All participants are automatically muted, save for the chair, until a speaker is invited to address. Throughout the meeting, the council ensures that all councillors have the camera on to ensure their attendance in order to maintain quorum. The officer controls the slideshow. So it seems to me that East Cambridgeshire have got it down to a T. And it seems to me that the key to the smooth running of a virtual meeting has the following ingredients. Firstly, the importance of having a dry run to iron out any problems. Secondly, having proper training of members so they know what the platform is. And thirdly, having someone with good IT skills on hand to address any problems immediately as they arise.
Thank you very much, Jack. Now we move on to the next issue. And this is a question from Ruben Bellamy of Lone Star. Ruben asked, do we really have to wait until May 2021 for neighbourhood plan referendums? And James, your view on that?
Well, Ruben, the simple answer is yes. If I say it all in one go, local governments and police and crime commission coronavirus postponement of elections and referendums, England and Wales Regulations 2020. So that's the name of the regulations, and the legislation is clear on this point. And until those are revoked, there will be no referendums. Now, in the interim, one can, of course, expect a great deal of reliance upon Section 72 of the Town and Country Planning Act 1990, with its specific reference to post-examination neighbourhood plans. Those are ones which have been approved for referendum by the council. So those post-examination neighbourhood plans must be taken into account as a material consideration. We can also expect local planning authorities to have regard to the PPG's guidance that such plans can be accorded significant weight. So in that context, they will be taken into account, and we can also expect that the authors of those plans, be they parish councils or neighbourhood forums, will no doubt refer to the high proportion of neighbourhood plans which have resulted in a successful referendum in any submissions to the council.
Thank you, James. And I'll just add a couple of comments on that. I mean, I think it was an extraordinary overreaction by the government to put them off until May 2021. Perhaps tells you a little bit about the dynamic of people pushing neighbourhood plans, or the demographic, perhaps, of people pushing neighbourhood plans and seeking to progress them. But it may be that they revoke that date back. I certainly hope so. What I would say is that you can obviously progress sites and progress planning applications because of the weight the government now gives to neighbourhood plans, even though they haven't been to referendum. Our final question is how to investigate and gather evidence on alleged unauthorised internal works to a listed building. Quite a tricky issue for enforcement officers and other local authority officers. And Jack, you're going to respond on that, please.
Thanks, Chris. The first point to raise is that there's no immunity in respect of works undertaken to listed buildings. So in the vast majority of cases, site visits at suspected unauthorised premises can be undertaken consistent with the social distancing rules. Unscrupulous people responsible for breaches of planning control could cynically use the lockdown as a pretext to frustrate investigations. And I think officers should be firm and not allow this to happen. If the owner or occupier refuses entry to an officer on the grounds of COVID, the officer should explain what adjustments will be made to reduce the risk, not to touch any items with bare hands and completing it as quickly as possible. If the view of a number of different experts of different disciplines are required, video footage could be taken by a single visiting officer, which could then be scrutinised by the various heritage experts at a later date. Ultimately, if entry is refused, the council can apply for a warrant at the magistrate court.
Good. Thank you very much, Jack. And the key message there, we had a few connection problems, but the key message there is obviously there is no immunity from enforcement as far as listed buildings are concerned, as some people discover to their peril. And therefore, it won't help perpetrators to deny access. Now, over to Leanne. You've got some thoughts on this as well.
I do, Chris, and might I say I absolutely agree with Jack that concerns regarding delay in undertaking site visits are misplaced. But that being said, site visits are permissible in law, and I've already detailed today my views in terms of Regulation 6 and also highlighted the PIN's recent guidance and their announcement that they will be commencing site visits now where it's safe to do so. And I really think the key, as Jack has said, is adherence to social distancing. And provided that's done, there's no reason why a site visit can't take place. I therefore agree that officers should be firm if somebody is seeking to refuse just on the mere fact of COVID being in existence, because clearly practical solutions can be found. However, what I would say is that officers, of course, need to be mindful to the particular circumstances of a case. So, for example, if you've got a building that's residential and there's somebody in residence at the time, and that person's being shielded, then a site visit to view internal works in that particular case would obviously be more difficult, and it may in fact be a situation where a delay would be reasonable in carrying out that visit. If someone's not shielding but they're just self-isolating, then I would just flag that of course that will only really add a delay of around 7 to 14 days depending on who has the symptoms, how many people are in the property. And so there's no reason why a site visit can't take place still within a relatively short period of time. If the building's non-residential, then of course the owner, or if they can't, some other person could easily attend to allow access with social distancing applied. So, unlocking the property at a distance and taking a step back for officers to gain entry.
Good. Thank you very much, Leanne. Well, that completes all of our 12 questions. I'll just try and bring everybody back on the panel. Thank you very much for everybody listening. This show is driven by our viewers, as they say on radio and TV. So we need your questions. Please do send your questions. If anybody didn't get to hear a full answer, perhaps if you contact Andy Bisbee at planning at no5.com, and we can send you the answer specifically if there was any connection problems and that answer was something that you specifically wanted to hear. Okay, thank you very much, everybody. Thank you, everybody, for listening. We had hundreds of people again, which is very flattering, and we hope you found that useful. And as I say, do send in your questions. So from me and the rest of the panel, thank you very much. And we will be back in 2 weeks' time, hopefully at the same time, and to answer more of your questions. Goodbye.